I'm going to add one here. I'm kind of frustrated. I don't know. You come out of the DA's office, and you're on the court side. I've been hearing opposition here, opposing views on why we're backlogged. I don't know that we're getting a real answer. Does anybody disagree with that?
Can I respond to that?
You sure may.
My opponent talked about people being out on bond and coming back into the system and over and over and over and over and over. The DA's office, when a defendant is out on bond on a felon and commits another felony, the DA's office can file a motion to deny bond. That means ain't no bond. That means you stay in jail. Do you know how many times in the last 3 or 4 years the DA's office here has filed a motion to deny bond? I can't remember one. Do you know why? The law also says if they file a motion to deny bond and the judge denies the bond, that the DA's office has to be ready for trial within 30 days. Well, that's more burden. We would rather just set another bond. And that's not right. It's not right.
Jennifer, would you like to read that?
Yes, and I'm glad to have the question. I'm glad you asked the question because let me tell you where the frustration is. I've never worked in a court where I didn't know that the judge was the boss. I've never worked in a court where a judge told me to be at a hearing and I said I just ain't going. That's not how this works. Let's be honest about it. That's not how this works. When I talk about making changes for youthful offenders, Judge Ruben Reyes does a great job in drug court, and it's great, but it has a small minority of people in that court. Most of your people who have drug offenses that we need to make a difference with are on probation and are under jurisdiction of each judge in that court. And each judge who has probationers under them is responsible for saying, let's have a hearing on something when there's a violation of a probation. That judge is the person who is the monitor. And that's where it falls down many times, is that it's too slow to react. The court is too slow to react. Well, let's talk about this. You know, the court sets the docket in Lubbock County. I've never set a trial docket in my 14 years of prosecutorial experience. You want to talk about bonds? Bonds are set, actually, in Lubbock County when someone is arrested. They go into jail. The Board of Judges here in Lubbock County has appointed magistrates who go in at night and set bonds. And they supervise those magistrates. Our office gets an ability to recommend what the bond needs to be, but that magistrate doesn't have to take it. And many times it's not taken. The court also has the ability to put conditions on bond. You stay 1,000 feet away from the person you victimized. You don't use drugs. You don't use alcohol. The court has that jurisdiction. The court also has the jurisdiction on their own motion to do those kind of conditions. They don't have to wait for a prosecutor. I myself have before filed a motion to deny bond, and it doesn't mean it's granted. That's a judge's decision. So in perspective, this is why people are frustrated with this system. My house has been broken into. Why has it been a year? Why is that guy down the street on bond? A court has the ability to put the conditions on the bond, to raise the bond. The judge is the person who does that. And the DA's office can bring it forward, but the judge makes the decision. I think what you ask for in your court system is accountability, flat out accountability, and not to react, but be proactive in your docket. Be proactive on your cases. You as the judge of that court, you be proactive in your cases. It is your responsibility to look at those cases and be proactive and not reactive. And I think that's the problem in the system right now. And in fact, if you look at the court system, each court can have trial settings up to 33 a year. 33 times a year, you could have a trial setting. In fact, you could do more than that. I've worked in courts where we trial 2 trials a week. Start one Monday, and jury's out on Wednesday. You start another one Wednesday afternoon. Now you're hustling, let me tell you, you're hustling. But that's what you should be doing, is hustling. If that's what the court wants to do, the court sets that bar. And that has happened in courts before. I've tried 2 cases in a week before, because that's how the judge that I was working for did it. And that can be done. It's all about leadership and accountability. And let me tell you something. Thank you again, and do ask you for your vote. It's time for fresh leadership and fresh vision and proactive. Thank you.
Brad, I have to respond to something Jennifer just said.
You can, that's fine. And then, go ahead.
I'm certain that she misspoke. I'm certain that she didn't intentionally mislead you. The way probations work, when someone violates their probation, the probation office, who are monitoring those folks on a daily basis, send a violation report to the DA's office, not to the court. The DA's office then decides whether to file a motion to revoke the probation or not. If the motion to revoke probation is filed by the DA's office, then the court has something to work with. We don't have the authority to go out and pick and choose defendants who are out on probation and say, okay, you're doing a good job, I'm going to leave you alone, you're doing a bad job, I'm going to revoke it. Courts don't work that way, and she knows that. Courts handle cases that are brought to them appropriately. And the appropriate way to handle a revocation is filed by the DA's office, not by the court.
I'm gonna, we are clap. I want to speak from a citizen's perspective. And when we started this back in February, one of the things that we hear over and over again is the frustration, not just with y'all. I thank y'all for being up here. It's not easy to stand by your opponent, but we're all frustrated as American citizens. It doesn't matter whether it's the judge, the precincts, the chairmen, the county judges, the commissioners. It's all frustrating. We can't seem to get anything done. Everybody wants to point fingers at each other and say it's their fault, it's their fault. However, our tax dollars and our bills are getting smaller and smaller, and the tax coffers are getting bigger and bigger and getting spent. It's frustrating. We just want action and response. We want to be able to, the people we elect, to fulfill their duty to the best of their abilities and to make sure we're getting the best bang for our buck. If my restaurant operated like our judicial system, like our government does, we'd have been out of business before we opened up. And that's sad. And so, does anybody else have any question? Thank you, Judge Tom Head,
You have a question?
David Nelson, and I'm going to give you the chance to talk about your ghost court also, but I want to make sure everybody's questions. Yes, Mr. Ronnie O'Neill, we have a candidate here in our house.
My question is to both of you this one. In the federal court system, they have a speedy trial act. I think the state of Texas might have tried that once and got overturned. Where Fed cases have to be tried in 180 days, or it has to be real complex litigation. It has to be a compelling reason to let that case go any longer. But something like that from our state legislature to benefit the state court system, if they were held to the fire and you had a speedy trial act you had to operate under.
You're right, Ronnie, we did have a speedy trial act, 32A.02 of the Texas Penal Code, I'm sorry, the Code of Criminal Procedure. And the Court of Criminal Appeals ruled that it was unconstitutional. So it would have to be carefully worded. But yeah, I'd love a speedy trial. You dang skip. I'd love it, but it'd have to be constitutional. It'd have to be very well written.
And we do have, there are times that people do file a motion for speedy trial and request their trial ahead of time. And I agree. I think that would be a great thing to have because, you know, delay really, truly, most of the time, benefits the defense. A lot of times when I try cases with children as victims, you know, if it's 3 years later, that child just became 3 years older. It is much more difficult to try those cases. You lose witnesses. It always hurts the state on the delay. So that's one of those kind of things that I think it would help immensely if we could do that.